I'd love to turn to the next topic, which is cybersecurity. This one I think is so interesting as these areas of privacy and security continue to merge.
So this one, a lot of the changes are so detailed. They are reflecting what business comments were about making this more frictionless and easier to implement. But I'll start with the timing because, that was really interesting what the staff came up with. So they decided to propose to the board that instead of there being one date, there be different dates based on your revenue. And that makes, I think, perfect sense. My clients that are smaller, that are going to take time, they don't already have the SOC 2. This is great. So I think that's where we're going to see a little bit of switching to between what we get final, because so I'd rather just say at this point, there's going to be phase-in dates, whether they start probably not before 2027 and going till 2030. But there might be 3 levels or there might be 4 levels of revenue. And then the other comment I'll just make about this is the zero trust architecture that is out.
Sounds a lot more reasonable to make it a sliding scale depending on maturity of the business. And lastly, let's talk about ADMT, which is, of course, automated decision-making technology.
Yeah. So I think it's important just to realize that we have narrowed the scope. So the definition of automated decision-making, they did talk about that at the April 4th meeting, and they had 3 options. So one option was like the business is making a decision solely based on the ADMT. And Alistair, who again was part of the whole process of Proposition 24, didn't want to go that far because they thought that would be too big of a loophole. But where the staff was at was on the other end, was substantially facilitate. So the middle ground is substantially replace. So I think the concern about where is that line going to be of how you're using ADMT, and from the business comments with things that are what he called just normal software use now, and just too much could be in. So the substantially replace was a compromise, and that follows Colorado. That's another theme that came up a lot in the April 4th meeting, is how can we make it easier by business to be consistent with other similar laws and implementation of it. I'd say that the key really here is having a human in the loop. I think we've all kind of heard that, to make decisions. You better make sure you have a human reviewer who, first of all, is authorized to overturn the decision. They gave this example in the medical field of a doctor, I don't know, 1,000 or some things that he was approving. There was no way that was really reviewing it, right? This is what I'm going to have to advise my clients. We can't just give a gut reaction. Oh, I don't think it applies. We're going to have to go through the data and decide, okay, now we're taking the position. This is like what I do with my clients with GDPR, with like the legitimate interest analysis or controller versus processor. We got to go through an analysis, and then we can take a position that we have a good faith belief that this is where we stand. And then unless that gets challenged at some point down the road. What I wanted to really talk about 3 things that are so key to think about with ADMT: pre-use notice, opt out, and request to access ADMT. We still have those requirements. Some of the changes that happen with a pre-use notice was it can be bundled with the notice at collection. That's the privacy policy. That should be easier for businesses. It's got to be plain language. They say not generic, like you can't say you're using it to make a significant decision. From the consumer point of view, what is the effect this could have on their life? And then you need to describe to the consumer that they have an opt-out right, unless they don't, because there's exceptions, especially in the employment area. And then how to submit request for access to the ADMT. You have to tell the consumer that there's no retaliation for exercising your rights. And then here's the big one for some of my smaller clients that are using AI. How does it work? If you're a smaller company, you need to have something there. And then what are the categories of personal information used? What are the outputs generated? There is a statement that says they don't have to disclose trade secrets, but again, that means an analysis. You can't just say everything's a trade secret. So that's then you got to think about the opt-out. So there's an exception if the human reviewer, again, has the authority to overturn the decision And they go into more detail in admission, acceptance, or hiring decisions, allocation or assignment of work and compensation. Those are, again, areas that we had a lot of feedback from business and their concerns. And then the final one, the request to access ADMT, that's going to be a lot of work. You've got to give a plain language explanation of purpose, logic, outcome, and then also your statements about no retaliation and you can protect trade secrets. But so the big move was to limit to the scope. But you're going to have to do an analysis to see whether or not you're in the scope.
Well, and as you walk through that, what occurs to me most, I think, is how clear it is that they're really trying to put themselves in the shoes of the consumer and make sure this is easy, right, for the consumer to understand.
Yeah, absolutely. And I think if we saw anything from the Honda decision, that's been the only CCPA enforcement action where we have a public consent decree from the agency for CCPA. Honda, they're a bigger company. They had done a lot of things to technically comply, but they were considered by the agency to overly burden the consumer to access their information, all of the verification steps and things like that. That's definitely going to be an enforcement priority for the agency. Is I think they're trying to balance it. And as the board members have all said, this isn't one and done. We can come back and we can review and see how it's working. And hopefully they'll continue to have kind of these forums and opportunities for both sides, for business and consumers and labor, to talk about how it's working.
The other thing I've heard from regulators too at some of these conferences over the spring season is just they're looking for businesses to show their work, right? It's like on a math test,
Yeah.
if you give the wrong answer, if you give the wrong answer with no showing of how you did it, you're not going to get any credit. But if you show how you got there, at least you're showing you're trying, right? Regulators want to see that businesses are making a best attempt.
Totally. You hear that over and over. Show your work. So I think we stay tuned for the July meeting that hasn't been announced, but it sounds clear that they're going to have a July meeting and we'll see what happens there.
Well, Jenny, thank you so much for being our eyes and ears at these meetings. It's great to have the detailed takeaways. I appreciate you sharing them with us.
Yeah, my pleasure. It was a lot of fun. Thank you, Colleen.
I can't wait to talk to you next time.